before we get started, turn it over to him. I want to thank the Triangle Apartment Association for hosting this once again. It's a great service to our industry. To thank them. I am pinch hitting due to unforeseen circumstances. Dustin, who was going to host, I was not able to host. So so pardon me if I screw anything up, because I don't dwell in a pinch sometimes. So.
But thank you so much for jumping in and moderating for us, John. We really appreciate it.
Absolutely. So any mistakes are mine. They have nothing to do with Chris or with TAA. So now we're covered. All right. Just a little housekeeping. If you are on a computer, if you want to ask a question, you can use the Q&A button at the bottom of your screen. I believe if you're on your phone or on a mobile, there's a participant section, and there should be a Q&A button in there. Anyway, wherever it is, look for the Q&A button. That's where you can ask your questions. If you see a question that you're going to ask that you really emphasize that you'd like to have it asked, you can hit the thumbs up button, and it'll promote it up. If you don't see a question, then you can type it in there, and we'll try to get to it as efficiently as we can. After we answer the questions, or after Chris answers your questions, they will go into the answered section of that area of Zoom. So you can kind of review, if you're worried about asking the same question, you can review the questions that have already been answered there. Also, this is going to be being recorded, and will be available later after the conclusion of the webinar. Will be available. I believe it'll be on YouTube, if I'm not mistaken, Meg. Okay,
correct.
So it will be on YouTube. Great. All right. I believe I've hit all the housekeeping items. So with that, I will turn it over to our friend Chris Loebsack. And Chris, thank you again for this.
Thank you, John. It's my pleasure. It's becoming a regular group chat. I wish I could see more of you, because most of you are folks that I think about on a virtually daily basis, because it seems like every 18 hours I have some new piece of information I have to respond to, digest, send out, otherwise advise on, ask 487 questions about, or answer 487 questions about. So welcome back. Good to see you again. I hope everyone had a good weekend. I'm sure we have a lot of the same people on webinar as we did last week. So this one is document intensive. There's only 2 documents for today. One came out yesterday. The governor of North Carolina released an executive order yesterday, and of course the big one came out last Friday afternoon. The CARES Act of 2020 was passed into law late Friday afternoon after being passed by Congress. It has 2 sections that relate to the status of eviction-related matters, and so we'll cover those. We will read them together so that you can see what they say. There's a lot of confusion out there about what each section says, how they work together, whether they both apply equally, and any number of other things. So this will be a little more actual document intensive than a couple of the previous ones, where we were just talking about what's the status of the courthouse and what is a little bit dense, and one of the things that we've noticed is that it's hard to make sense of some of the language, because Congress did it in such a condensed time frame. I think a lot of the language still has a number of holes that need to be filled in order to be able to address, and that's going to take some time. Congress is not just doing business all the time, and so until we have another meeting where the congressional leaders are trying to put more relief in place, I think we're going to just have to do the best we can with what we are given right now. But I think there's definitely a lot of issues that remain to be addressed. There's a lot of information that needs to be gathered from the federal government in order for us to be able to figure out how best to implement the provisions that are in the law. And so everyone's just going to have to be patient as we wait for more guidance to come out. But we can talk about what it does say, so that we know for sure. There's a few things that we know for 100% certain that you need to know now, and there's a lot of other things that remain unknown right today, but we'll know them soon enough. And of course, we'll keep talking as the information comes available. So Meg was kind enough to start. We're going to start with Governor Cooper's order from yesterday, because this one is probably the less weighty of the two, but it is noteworthy. So yesterday afternoon, Governor Cooper issued Executive Order number 124. This one is entitled Assisting North Carolinians by Prohibiting Utility Shutoffs, Late Fees, and Reconnection Fees for Utility Services. Also providing guidance about eviction processes, which is what we're going to talk about, and then also addressing issues relating to telecommunications providers, banks, and mortgage servicers about flexibility with their customers. So if you go to the section that deals with evictions, we've cut and pasted just the sections that are relevant to this conversation. Section 3, let's see, there we go. If you scroll up, Section 3 of his order is guidance concerning eviction proceedings. So if you haven't had a chance to read this yesterday, we're going to go through it right now. Governor said yesterday afternoon, as guidance for North Carolinians, he is highlighting and explaining the effect on evictions of the March 13th and March 19th orders of the Chief Justice of the Supreme Court. Those are the ones that we talked about in our seminars a week and 2 weeks ago. Those orders were analyzed by the Attorney General. He consulted with the governor on drafting of this section of the order so that it helps provide guidance as to what the Attorney General believes the Chief Justice's order means, and that's very much similar to what we've already done in our prior meetings with each other. Is I've told you what I think they mean, and I don't think you're going to find anything in this section that differs from what we've already talked about. Pursuant to those orders, there should be no new eviction proceedings until the orders expire. That's not news. If you've been playing along with us, the Supreme Court Chief Justice entered orders that said that all eviction proceedings should be halted. No new cases should be heard by magistrates, even if they've been filed and even if they were scheduled for hearing, until after the date of April the 17th, as of today. Because the Chief Justice felt like that was a 30-day window from the issuance of her order, and that would give North Carolina time to evaluate the COVID situation, how it was impacting gatherings of people, what the latest medical recommendations were in regards to how many people can be in a gathering at one time, and the conduct of small claims and eviction court hearings requires a lot of people to be in a courtroom at the same time, generally speaking. And given the number of cases that are typically heard in any of the significant metro areas of our state, it would be pretty hard to conduct eviction hearings if you have a limitation on the number of people that can gather together at one time. So in that time window, the recommendations have gotten tighter and tighter. And so to my way of thinking, it's only a matter of time before the Chief Justice herself extends the order beyond April 17th. Because we are getting guidance from the governor and from all of the county health departments that fewer and fewer people should be allowed to gather. Now we're currently under a recommendation of 10 people or less. And you would be hard pressed to come up with any way that you could conduct eviction court hearings for any possible scenarios using that as your limitation. So with that limitation in place, it's pretty apparent that the governor's order directing people to stay at home and not gather in groups of more than 9, which stays in effect through at least April the 29th, the governor's order does. It's pretty apparent to everyone that the Chief Justice is going to have to issue a new order extending the April 17th deadline out into the future. Just a question of how far out in the future she will go. But and it's also a question of when she'll issue it. But I imagine she's got some time. She's probably going to wait and let the situation evolve further before she makes a decision about how far out to extend her order. She probably doesn't want to have to keep issuing orders every 2 weeks. So I suspect that you're going to see her wait closer to the April 17th deadline to get a better handle on what our environment looks like before she issues another order, pushing the case deadlines out further. That's the reason why I don't think we've seen her simply match the governor's April 29th date yet, because I think she's probably concerned that she might need to push it even further than that in the coming weeks. So I suspect we will probably not hear from her for another week or 10 days, if I had to But I'm pretty sure that you will not have any court hearings before April the 29th, even though right now, April 17th was the deadline she gave in her last motion order. So pursuant to that, during the time period, there should be no rental bonds due. So that sentence clarifies for everyone that has an eviction case that was appealed to district court. It doesn't happen all that often. It's usually around 2% of the cases. But for anyone who's ever had a case appealed, you know that the obligation of the resident during the time of that appeal is to pay their rent into the courthouse to the bookkeeping department as their rent comes due. So in this case, if you filed an appeal of an eviction that was held in early March, and you made your notice of appeal, the court would typically require you to, right around now, April 1st, be paying a rent bond to the court for the month of April. And you usually have a window of about 6 or 7 days to get that done. But since that 6 or 7 day window falls in the first 7 days of April and before the April 17th deadline, the Chief Justice and now the Attorney General have made clear that those rent bond payments, even though they are normally due first 5 working days of a month, are not going to be due until after the 17th of April at the earliest. The clerks of Superior Court, in their discretion, may delay until regular court operations resume, issuing writs of possession for real property, which are the legal documents under which sheriffs perform evictions. This is from the governor through the Attorney General. So, for clarity, the governor is still not prohibiting clerks of court from issuing writs of possession if they were validly entered before the stay went into place on new eviction hearings being held. So if you had a case heard before March 16th and you got a judgment and it wasn't appealed, this is from the governor telling the clerks of court that they may, if they choose in their county, delay or issue writs of possession in their discretion. So what that means is when all of our clients ask us routinely, can I get my writ issued? What's going on? The answer is, it depends on your county clerk. And now that we got this directive from the governor yesterday, we know for sure that it does in fact apply, and there is wide discretion given to the clerks to conduct that portion of their business how they choose to in their particular county. There's no mandate that they issue the writs. There's no mandate that they not issue the writs. They simply have the discretion to decide for themselves how they want to handle that business. The Attorney General and the governor conclude that paragraph by saying they strongly encourage all clerks to follow, however, the spirit of the Chief Justice's order. And unless they really, really feel strongly, he would like them to hold the issuance of the writs of possession of real property until April 17th. It's pretty unlikely that with that strong recommendation, strong encouragement from the governor, it's pretty unlikely that you're going to see any clerks, except perhaps in some small outlying areas, go against that directive. And so I think you're going to be safe in assuming that new writs of possession, even if you're entitled to one from a March 12th hearing, for example, are not going to be issued by the clerks until at least April 17th. And whether or not the sheriff conducts those lockouts also remains to be seen. And the next paragraph addresses that. Everyone who wants to know when is the sheriff going to show up and do my lockout should refer to this paragraph. Further, the undersigned, the governor, and the Attorney General strongly encourage sheriffs to delay until further court operations resume the execution, i.e. the lockouts, on any writs of possession for real property that have already been issued, consistent with the spirit of the order in support of public health and public safety. The sheriffs don't want to be doing lockouts right now because they all are in an election cycle, and they don't want to be the subject of public derision. They don't want to be the subject of news stories. They don't want to be asked repetitively why they're locking people out in the middle of a crisis. So the governor is doing them a favor here by giving them cover so that they can say the governor and the Attorney General strongly recommended that we not do lockouts right now. And so we're going to follow that directive and not do lockouts right now. So when you're looking for reasons as to why you haven't seen a lockout happen yet, this is why. the sheriffs were looking for some opportunity to take advantage of this. The governor heard their concerns and has basically issued his executive order, giving them the leverage they need to tell everyone, we're sorry, but for right now, it's in everyone's best interest that we just wait on those lockouts and execute them after the public health crisis has been put behind us. That's what you're going to hear from everyone. Finally, the undersigned and the Attorney General strongly encourage, again, you notice you use the same language in all three, and this one's a very important one. Strongly encourages all property owners who are landlords to work with tenants to the best of their abilities to implement payment plans and try and avoid evictions in light of the state of emergency in North Carolina, including canceling pending evictions by notifying the relevant sheriff's office. So the governor would like you to strongly consider, if you have a writ of possession that's already been issued, that you notify the sheriff that you're canceling. Whether or not that's a good idea, whether or not that's something you choose to do, is going to be obviously something you should take up with your appropriate management and the powers that be at your company. But the governor would like you to strongly consider just letting it go by the wayside. I think the governor may have forgotten that if you do that, the writ of possession then becomes void and your eviction judgment is also void, and you can't reissue the writ later. And so you would have to basically just wait and start over whenever we get started again. I think that is, I think that's nice for him to say, but it's not practical and it's not pragmatic for you to follow his advice and notify the sheriff that you're agreeing to stop the eviction process in that case, knowing that that means you have to start from scratch some unknown point into the future, even if this resident chooses to not accept your offer to work with them and implement a payment plan, because the resident is under no obligation to do that. The resident just wants you to let them stay without paying. Unless you can get them onto a payment plan, there is no reason to follow the governor's suggestion of just simply dismissing your validly issued writ of possession. If you get a payment plan with a resident, however, that's something different. And so really the question you're going to be asking yourself is, with regard to this particular writ, since I now know that the sheriff is not going to execute the writ and perform a lockout for several weeks yet at best, then does it make sense for me to contact that resident, even though I have an eviction judgment, and see if there is some way to implement a payment plan, as the governor strongly encourages you to? I don't think there's any reason not to, if the resident has, subsequent to you getting the judgment, come up with some way of getting some payment put together, having a payment plan that's viable. They've started receiving their unemployment assistance that covers their full paycheck, things like that could have happened. I think that makes sense, and I think the governor's advice in that regard would be okay. If you know that you can't pursue the writ right now because the sheriffs aren't performing lockouts, then there's no harm in reaching out to all those residents and saying, hey, the governor has asked us to reach out and encouraged us to see if there's a payment plan we can work out with you. Can we sit down and talk about that? That would be fine. That would follow the guidance from the governor, and it would be in the spirit of the governor's intent. Whether or not the resident can, however, is the issue. And I think this is where most of our clients are going to find themselves stuck in a no man's land here for a period of time. It's one thing to say we encourage you to try and work to the best of your ability to implement payment plans with your residents. That's fine. I don't know very many clients that wouldn't be willing to, and most of them have sent me copies of documents showing that they're planning on implementing payment plans. But that doesn't mean that the resident is going to agree, or that the resident has the ability to agree to a payment plan. If they say, I don't have any money, I don't know when I'll be able to pay you anything, how exactly is it that you're supposed to implement a payment plan when the answer you're getting from the resident is, I can't make any payment? And I think that's the nicety of being the governor, is that you can say things that sound really great in theory and make sweeping pronouncements and sweeping encouragements to strongly encourage us to implement payment plans. I think everybody that I know is already agreeing to put payment plans in place. The problem is going to be that requires the resident to actually sit down and commit themselves to a structure to get those payments down on a paper that they've signed on to and said, I agree that I'm going to make these payments. If the resident won't sit down and do that, then you can't implement a payment plan because payment plans require both parties to be involved. So there's no way
Hey, Chris, something happened and we lost your audio. You've accidentally muted yourself, I think.
Okay, sorry.
We lost that last sentence or two.
Yeah. So I think it's, so yeah, the reality is that the governor's advice is fancy and sounds great. And I think most of our clients all agree that it's exactly what their plan is going to be, is to try and get people to sign on to payment plans and make arrangements for payment. The dilemma will be, how do you handle the reality of the situation, which the governor and the attorney general don't address in this memo, of what do you suggest we do when the tenant says, I can't or don't want to pay anything? I don't want to be on a payment plan. I want you to waive my rent. And the answer is, they don't have an answer for that. The government doesn't yet have a solution for how are we going to handle that. And even the federal government has done a very limited job of that themselves. But yet they leave the issue unspoken and they leave the issue unaddressed, because what the public wants to hear is landlords should be avoiding evictions whenever possible during this time of crisis. What the government isn't saying is, and in order to encourage you to do that, we're going to pay you all this money to cover the rent that didn't get paid by the tenants, who still don't have any way to come up with a payment plan because they still don't have any money. And that's the piece that's going to be hard to come by. The government doesn't know what it's going to do. The government doesn't have a plan for how it's going to cover that problem. And yet they just keep issuing directives as though they are wanting landlords to have all the solutions, as though implementing a payment plan is the same as getting payment from people who don't know where they're going to get their money. And I think that's a big problem. It's one without a solution for us as practitioners. We know the realities of the situation, and I think it's going to be important to recognize that. And then as you continue on with the conclusion of this paragraph, you'll see similarly the undersigned governor and the attorney general strongly encourage all lenders to work with property owners to the best of their abilities to provide loan payment flexibility that enables property owners to avoid eviction of tenants in light of the state of emergency in North Carolina. So the governor's further recommendation is that they would like your lenders to try and allow you not to have to make payments so that your tenants don't have to pay you. Again, that's great and it sounds good, but basically it says that the government wants all of these private businesses to do the government's job of subsidizing the directives that it's making. We want people not to get evicted, and we want you, the landlords, to be okay with them not making payment because they're in crisis. And we want that to be okay because we want the people that gave you the money to buy your property with to be okay with you not paying them either. And the government somehow thinks that that's going to just magically work. And I am, as you can tell, dubious. I am highly skeptical. And I am pretty positive that it's all going to not work at all like the governor would love for it to, with this fancy encouragement language, unless and until the governor is volunteering to pay money to those lenders out of the state's pocketbooks and out of the state's operating account so that the lenders are actually being made whole. There's almost no chance that the lenders are going to let the owners not make payment to them so that the owners don't have to demand that their tenants pay them either. It's the worst kind of social engineering because it relies on somebody just doing a good deed for the state when in fact it's the state's job. And the governor saying to private lenders and mortgage holders that they provide mortgage loan flexibility is great, but it's not a plan. It's not anything other than pie in the sky rhetoric. And at the end of the day, unless and until the state of North Carolina has a plan on how they're going to allow lenders to be made whole, there's no chance that the lenders are just going to say, you know what, the owner of this multifamily apartment community that cost $28 million to build really does deserve a break. And we're going to let them not pay their mortgage for the next 3 months because we know that the residents are having a hard time. It's just not going to happen that way. And so I think the reality that we all have to face is that the governor wants everyone to play along. And I think it's important to recognize that in what you do next. Your operations decisions need to reflect that you understand the governor's directives here. You need to be mindful of these things when you're messaging your residents about what you're willing to do. Implementing payment plans clearly is a good thing, and clearly you should be talking about that to your residents. You should be sending communications to them that indicate that you want to implement payment plans with them so that you can show everybody who might ask that you are in fact following this guidance. You can't make the payment plans materialize without the residents' involvement. And so that's where this will really struggle, is after we tell people that that's what we're doing, it's up to the residents to actually take you up on the offer by being engaged in the process of creating a payment plan and then following it. And that is really where the proof will be in the pudding. Weeks and months from now, we will see whether this actually works or whether it doesn't, or if it does, how well does it work. But for today's purposes, for this call, it's important to note that this is a very important thing. If you are one of the few clients that I've interacted with that hasn't yet put together a payment plan protocol, then pretty clearly this is your call to order. The governor has told you that that's something you should start doing today, because that is now the directive and the strong encouragement from the governor's office, and there's no reason for you to be one of the outliers who doesn't have an answer for tenants when they come to you and say, hey, I'd like to be on a payment plan. You definitely should have that lined up. And if you don't, today's the day to get started doing that. So before we leave this and move on to the federal side, overall, then it's important to realize that this order from the governor doesn't actually change anything about the plan for eviction filings that we've talked about so far. The availability of the court system to accept new cases is still in place. And so throughout North Carolina, given these issues and these limitations, I think it's more important than ever to continue to follow your protocol and to make sure that you are doing what you can do to stick with the protocol that you have in place. If you have need for modification of that protocol, then now is the time to do it, especially in the wake of this executive order. Would be a great time to make any modifications you might want to your timing of your process, the manner of the process, how you choose to go forward from here. This would be a good time to evaluate those and make sure you've got things in place that are mindful of the times that we are now living in. So whereas you might usually send a demand letter following a failure to pay rent, you might revisit the timing of that demand letter. You might change the timing and push it back a few days to be more agreeable, to be more flexible, to do what the governor's encouraging you to do, and to work with tenants to the best of your ability, so that you can avoid unnecessary evictions from happening. The truth of the matter, though, is that if you do nothing, and if you cannot get people to take the governor's suggestion to implement payment plans, then there aren't any other options. You either do nothing and let the people not pay you and be okay with that, or you offer to implement a payment plan. And if they agree to that, then you move forward with that. But if you can't get one of those two things done, then your only recourse is the court system to indicate to people that they are in fact under a time deadline, and they do in fact have to at some point come up with a plan. If they're not willing to sign a payment plan up front, then having an eviction case in the queue at the courthouse is your only other option, other than do nothing and choose to be okay with it. Shrug your shoulders and say, well, I guess we're just not going to get money from them. And that obviously is always an option, but not a good one. And so for us, for so long as the courts of North Carolina are open for business, we are going to be filing new eviction cases. If nothing else, then as not just a placeholder so that you have your place line, but more importantly, as an incentive for the residents to realize that there is a timeline here. They do have to follow the Attorney General's guidance, and they do have to work with their landlords to come up with payment plans. You cannot do nothing. You cannot not pay rent. That is not, unless and until the government comes up with a big pot of money for people to use and dip into to pay their rent as a benevolent governmental gesture, then at some point people need to pay their rent. And while our courts are open, the way to ensure that you keep people honest with their assessment of their situation is by filing the eviction action and getting it scheduled for a hearing, even if the hearing is not even this month at this point, even if it's sometime in May, or even if it's later than that. As we get towards the end of the month, I'm sure we'll be into June already. But having the cases filed, having the hearing scheduled is, in fact, a step that makes sure that even your best intentions and using the best of your abilities to get payment plans in place, you're going to need motivating factors so that the recalcitrant ones, the hesitant ones, or the ones that are just looking to try and take advantage of the situation, know that at the end of the day, there will come a time when they have to put up or shut up. And so that's why we're going to be here doing our jobs for you. Filing the cases is an important step in the process. Whether you proceed to evict people through writs of possession is, I think, the bigger, more philosophical conversation that the governor wants to impress on people. Not making people homeless is not a governmental objective. Or I say, making people homeless is not a governmental objective. They want you as the landlords to try, especially in these difficult times, to do everything you can to reach a different outcome. And there's nothing wrong with that from our perspective as attorneys for landlords. You want your tenants to remain your tenants. You want them to remain your tenants because they've gotten current on their obligations. And that way you don't have to worry about trying to replace empty units and fill them in a time of crisis. So everybody is operating towards the same goal. Keeping as many people in their apartments as possible is, in fact, the goal that we share with the governor as an industry. But we don't do it at the expense of our clients' pocketbooks. The people need to be making payment to our clients in order to stay in the units. And that's where I think the public sentiment is divergent from, the governor knows this, he's an attorney. His attorney general knows this, obviously he's an attorney. The public perception, however, on the other hand, is, as you've almost certainly seen, there's lots of groups out there now that want to try and leverage the public opinion into forcing landlords to let everyone live for free for a while. And that's just not something we're going to espouse. That's just not something that we're going to be okay with. And in our world, the courthouse is the way you keep people honest in their assessment of their situation. You are going to have some time. There's nothing we can do about it if the court's not scheduling hearings for a month. I can't evict you if I can't get a hearing held. But that doesn't mean we're going to sit back and do nothing and let your perception of the situation be that we are choosing to do nothing, meaning that it's probably okay for you to keep not paying us. That's the key component here, is that you have to use the methodologies that you do have available to you, even in a time when lockouts are, as you see from above, not currently available. What you do have available is continuing to utilize the process and keeping your tenants honest in their assessment of their situation, saying, we understand and we're going to work with you, but if you choose to ignore us and you keep not working with us, then we have no choice but to use the courthouse, which is what we're doing. So I think that's the way to think of it, is be mindful of where you are and be mindful of what the governor is talking about here, but also there's no reason why you cannot and should not keep doing the things that you have available to you as options to keep the system level on all playing fields.
Hey, Chris, wanted to ask you a quick question. Would you like to take some questions now before you go into the federal section, or do you want to?
Yeah, that's totally fine.
Okay.
I don't mind. Go ahead. Fire away.
All right. So a couple that have been submitted. First one was, are dismissed cases being dismissed with the court to help clear up the docket?
The court isn't dismissing cases on its own. So cases are only being dismissed if you are seeking to dismiss them. So
if Robin is a client of our firm, this is Michael talking, if Robin is a client of our firm and she dismisses it in our software, what is our team doing for her?
Oh, So yeah, if you have reached a payment agreement with a resident who came to your office and you got it organized, or they made payment and you've chosen to accept it and discontinue that eviction filing, then when you let us know that you're ready to have that case be dismissed, we will simply go ahead and prepare the dismissal and then send it to the courthouse and ask the clerk to file it and note that that case can be removed from the docket. Normally we do this in regular times. We do this at the time of the hearing, since it's usually 10 days or so before we have the hearing. We usually just bring all the dismissals with us and hand them up to the magistrate to put them in the file there. But in these times when there's no hearings being held, we'll simply print the dismissal and then mail it to the courthouse and ask the clerk of court to stamp it into the record and put it in the court file for us. The resident will then receive a copy of that by mail.
Okay.
Yep.
Next question is, are evictions being handled differently for criminal activity, or are they also on hold? And if they're on hold, what is the best way to approach these situations? These are outstanding warrants, restraining orders, et cetera.
Yeah. Everything is on hold. It's not that certain eviction cases are on hold. It's that right now the North Carolina courts are not having hearings. So it doesn't matter what kind of case you have, there's no hearings being held. In theory, if there was a public safety risk and you needed a domestic violence protective order, those are still exempted under the order from the Chief Justice, and you can have an audience if you need to. They will even have an electronic hearing if necessary, so that public health and safety issues can be addressed. But regular hearings for any type of eviction, whether it's non-payment, whether it's unauthorized occupant, whether it's criminal activity, those are still not being heard in the civil side of things.
All right. This is somewhat related, and I think you've answered it, but it's just confirmation that you can file evictions. There just won't be any actual action until the court system reopens in the future.
That's exactly right. The courts are still open for business. They will still accept new filings. They will still accept new cases, and they will still schedule them for a hearing at some point. The filing of the case is at this point simply just being placed in line, and they're just being reserved a spot. And whenever the courts reopen for hearings, probably every county will have its own unique protocol, because every county isn't the same size and doesn't have the same staff. So every county will likely have a different procedure that they use to get through their backlog of cases. But for right now, they're just scheduling them out into the future as though it was regular business, just being done further out than it normally is.
Okay. You spoke of demand letters. Does that also go for NSF letters telling them we will file if they do not pay in 48 hours? Every letter is different, and so there's no one way to answer that question without possibly getting it wrong, because your letter might say something that isn't what I'm answering. But there's nothing in the state, the executive order from the governor that prohibits you from doing your business as usual. We're going to get into the federal statute, which creates a whole different can of worms that we're going to open up here in just a minute, dealing with late letters and NSF fees and things of that nature. And so there's definitely some reason to be cautious about that. And once we finish talking about the federal CARES Act and its prohibitions that apply to certain properties, you'll have a better handle on that. But NSF fees are a creature of statute. Every state has a different one. And in North Carolina, if somebody bounces a check, you're allowed to tell them that they bounced a check and that you want them to make it good. But whether or not you can charge them a fee associated with that remains to be seen based on what the Federal CARES Act does actually specify. And that's one of the questions that isn't easy to answer because the language is unclear in the CARES Act. But we'll talk about that in just a minute. Okay.
What else on the state side?
And I'm going to save some of these questions that we already have because I think some of it might be addressed, or we can bundle them all together. Sorry. One that is, I do think is still specific to the process at the courtroom is we mailed our court filings to the clerk's office, which was what was instructed. We received them back in the mail yesterday. We haven't called yet, but any recommendation other than calling and asking what's going on?
He followed up right after that it was Orange County, Carborough. if that makes a difference.
Got it. Yeah. No. The simple answer is to check with the clerk of court and find out why it came back. If if they're sending it back to you, they must have a reason, and whether it's a technicality or whether it's just we don't want it, you would want to check with them and ask them why they sent it back.
Okay. A bunch of these questions are based on payment plans. Is that better to address now or to wait until after you cover the CARES Act?
I mean, we can bang them out now because payment plans are the act. The federal act doesn't apply to payment plans, doesn't specify them, so it would be relevant regardless of what the act says. So yeah,
Okay.
Let's just bang them out.
Do you have examples of what others are doing in regards to payment plan is one, and I'll give you another related to that. Do they need to be the same relevant to rent in order to stay in compliance with fair housing?
Okay. So I have great examples of what others are doing. Both the NAA and the AANC put out sample forms that are available for everyone. So go and find them, and I'm sure that Meg and the powers that be can highlight that email that went out to all of our members. I want to say it was last Friday, but can't remember specifically. But yes, NAA on the 25th released their documents, and the AANC released theirs just a day or two later. So yes, highly recommend those to you. They're available for all members. What was the second part of the question?
Whether they have to be the same for fair housing reasons, especially as regarding the actual rent, the amount of rent.
Yeah, the Fair Housing Act hasn't been suspended, so the Fair Housing Act is always an issue. And so no matter what you're doing to work with your residents, it has to be done on a consistent basis. You have to have a plan for how you're going to do it. You have to have a plan for determining who's eligible. You have to have, just like you do for rental criteria, when applicants want to rent an apartment from you, you should have an exactly similar protocol put in place for how you're going to handle payment plans. Not everyone needs a payment plan. Not everyone has lost their job. Not everyone has lost their income. Not everyone has been affected in any way at all by the virus. And so there should be eligibility requirements, but those requirements should be uniform because, again, the Fair Housing Act applies the same to everybody. Even in a time of crisis, that hasn't been suspended. So yes, it should be very clear that you are creating a set of eligibility criteria that are uniformly applied, just like you do eligibility criteria uniformly applied for applicants who want to move in to your apartment community.
Okay. Meg has, just so everybody knows, if you look in the chat box, Meg has put in links to the NAA payment plan agreement template. So you have that for your access if you need it. Another question, does the order from the governor require that we waive late fees across the board, or are we in the wrong if we ask documentation that the late fee inability to pay is related to COVID?
So the late fee question is going to come up in the CARES Act, so we'll save that one for later. If your
Okay.
property is covered, if your property is a covered property as defined in the CARES Act, you are not allowed to charge late fees at all to anyone. So we'll talk about that in just a minute.
Okay. Also, this might be somewhat similar. If we have residents that are saying they're moving out due to COVID-19 situation, what recourse do we have as far as them breaking their leases?
The same as you always do for anybody that skips out in a non-crisis situation. If they get a job transfer and have to move to Atlanta and they leave saying, hey, look, I know I got 7 months left on my lease, but I got to move to Atlanta, so I'm going to be moving out. Your recourse is still the same. They have a lease that obligates them to pay rent every month on the 1st of the month and a late fee every month on the 6th of the month. If you're a covered property, your late fee will have to go away. But if the resident is leaving as a result of a COVID issue and that's what they tell you, that doesn't change their lease. That doesn't mean that they're absolved from the obligation to pay rent on the 1st of the month. It doesn't prohibit you from expecting them and ledgering them for the rent payment every month on the 1st of the month until their lease runs out or until someone moves in. But under the COVID environment, just as under a regular environment, it does not allow you to simply charge them some predetermined fee that is often referred to as an early termination fee that many clients mistakenly think that they are allowed to do if you move out early in your lease instead of signing a early termination agreement. If they sign an early termination agreement, that's one thing. But in this situation with the health crisis like it is, if people are leaving because of that, they're not going to be agreeing to give you 60 days notice and pay you 2 months worth of rent in addition to moving out. So if they, or when they don't agree to that, you still don't have the power to just assess them an early termination because they didn't agree to pay one. Agreed to pay you rent on the first of the month pursuant to their contract. So you can keep charging them rent on the first of the month until the unit is re-rented, just like you always could. Nothing has changed.
Okay. One pretty specific question here. Can you elaborate on utilities that are billed back from the property to the residents? Are properties required to provide a 6-month repayment period on those like utility companies?
I don't know. It's a good question. The governor didn't address that. His executive order doesn't say that specifically. And so I think we're going to have to get further guidance from the governor about that. But it certainly doesn't, from the landlord side of things, it doesn't change the eviction actions because the law still is the same as that you can't evict people for not paying their utilities and their submetering. So it doesn't really impact the eviction process at all because you wouldn't have been able to evict anyone because of that in the first place. You certainly can't now. But in terms of how do you handle it as a utility service provider who's submetering their water or other services, I think you might have to get clarification from the Utilities Commission about that.
Okay. Last question I had queued up here was I've had some memberships still ask about non-renewals for residents whose leases are coming up at the end of April. So
Okay.
I'm not sure how to address that.
Yeah. I'll use it as an opportunity to highlight one standard piece of advice that I give, and that is non-renewals are not an advisable way of removing people from your apartment communities. Non-renewals, unless done by a specific protocol that's in place in writing, whether it's an internal one or an external one, if you don't have a policy that says at this community we rent to people for 12 months and we non-renew everyone who doesn't do the following things, and you follow that religiously, then that's fine. And you can non-renew people in accordance with that policy. Anyone who is late on their rent payments more than 5 times in a 12-month period is not offered a renewal lease. Okay, that's fine. That's easy. And you do that for everyone. But what a lot of people do is they still have the misperception that you can just non-renew someone that you don't want to rent to anymore. You are legally not obligated to keep renting to anyone. But the problem you have is that if you pick and choose who you don't renew on an individualized basis, in today's environment, that's a Fair Housing Act lawsuit waiting to happen because you are specifically singling that person out for different treatment by non-renewing their lease when everybody else at the community received a renewal letter except that one person. And that one person can then easily say, I think you singled me out because you don't like the color of my skin, or you don't like the accent that I speak with because I'm from a different country, or because that I have kids that you think are annoying and you don't like, or any number of reasons. And whether those are true or not true isn't the point. Dealing with a fair housing claim is penalty enough to keep you from doing that. So you shouldn't be non-renewing anybody unless you're doing it pursuant to a written policy that is dispassionate and applies equally to everyone. And that is a rare policy in my experience. Though they don't exist in many of our clients, in many of our clients' operational guidelines. And so non-renewals should not be a regular part of what you do. Least of all if you're trying to get rid of someone who you consider to be a problem and you just wish would go away. That's for sure the time to not use a non-renewal, because they will almost certainly continue to be a pain in your neck by retaliating against you by filing a claim for fair housing. So don't do it. And in this situation, non-renewing people whose leases are coming due at the end of April is probably even worse because now you're going to have a PR nightmare on your hands too. Whether you can evict them or not doesn't really matter. If you non-renew them, instead of evicting them because you can't get an eviction hearing, that doesn't do you any good. If they don't move out at the end of April, which they won't, you still have to file an eviction action to enforce the non-renewal notice. It's just for holding over after the expiration of the tenancy instead of not payment of rent. But it doesn't get you to court any faster, and you're still dealing with the same temporary suspension of court hearings. So the eviction action you have to file for a non-renewal of people is the same problem as if you filed the eviction action in May for non-payment of rent.
Okay.
or file this month but not paying April rent. So all those things combined to say the non-renewals are probably not your best option. But even if you think you have a good explanation that's different than what you just heard me say, definitely call your lawyer and ask.
Okay.
Chris and John, we're coming up on noon, which was the original time to end. We are going to extend. For anyone on the call, please feel free to stick with us. Obviously, we will take the time that we need to go over the federal and CARES Act. I just also wanted to remind anyone, if you have to jump off because you have another meeting or call, this is being recorded. As soon as we finish, I will be uploading to YouTube, and then I will be emailing all registered attendees a link to the webinar. So if you have to jump off, you will get the recording by this afternoon.
Okay. Thanks, Meg. Chris, real quickly, just clarification, and then let's move on to the federal. They said, just to be clear, they could still do the early termination fee charge on the fee, even if it's COVID related, same as any other process, right?
You should still offer anyone the same opportunities for fair housing reasons. If they say, I need to break my lease early, you should follow the exact same protocol you always follow. If that involves presenting them with an early termination agreement opportunity, you should do the same thing for someone in today's environment, because you want to be consistent from 1 month to the next as to what you do. Now, the likelihood of a person who's impacted by COVID accepting the offer for an early termination agreement is low. And so I wouldn't expect them to say, yes, let's do that. But you should still offer it to them the same as if it was February instead of April 1st. If it was February 1st, that's what you would have done then. You should do that now too. Stay consistent in your approach. Follow the same practice and procedure you always do. Just make sure you're not assessing early termination fees to people that leave early because they probably have not agreed to those. And you definitely, if you think differently, then you should definitely seek legal advice from your attorney about the specific situation you're talking about, so they can make sure you're not falling short on the legal side of things.
Okay. All right. I think it's safe to move on at this point.
Yeah. Okay. So the big bad federal CARES Act. This is going to be, I intended for this to be the shorter version because this is going to be talked about many times in the future. And so today's purpose of this, and Meg, I was trying to do it in time, and thank you for extending a little bit, and my apologies to anybody that we're running over, but I don't anticipate running over more than a handful of minutes here, because the purpose of this part of the speech today is to introduce the idea to you. There are going to be a million questions, and I'm going to have no answers for most of them because it's literally 2 days old, and the definitions are vague in many respects. And in order to know if this applies to your property, you're going to have to do some very high-level homework. So I'm not going to give a lot of answers for this part of it, because there is a lot of preparation and homework you have to do first to even know if this applies to you. But let's go through it so that you're familiar with it, and then in subsequent seminars we'll talk about this in much more detail, because I think this is one where I think what I want is I want you to be aware of what this says, so that before you get to April the 7th and you're normally sending out late letters, I want you to be aware of what the issues are so that you can investigate and figure out, what do I need to do at my particular property. So this is not going to be a long, voluminous dissertation on what the CARES Act says or what it means or what all the permutations are. That's a seminar for another day, which we'll be doing soon, I'm sure. But this one is to make you aware of what the issue is, so that you can find out, does it even apply to me at all? Okay, so the CARES Act is very, very long. Fortunately, there are only 2 sections that apply for our purposes today, 4023 and 4024. So whichever one, this one can be referred to as the Coronavirus Protection Act or the CARES Act. So,
Chris, you got muted again.
4023, I think, right? Can you scroll up for me, Meg?
Yep, she's got it on 4023.
Okay.
Forbearance.
There we go. Yep. Forbearance of residential mortgage loan payments for utility properties with federally backed loans. Okay. So this provision is interesting and has caused a number of questions. But what this one says is that if you are the holder of a residential mortgage loan on a multifamily property with a federally backed loan, you have the ability to request forbearance for your mortgage payments to your lender for your community. Request for relief, paragraph B, says a multifamily borrower with a federally backed multifamily mortgage loan that was current on its payments as of February 1st may submit an oral or written request for forbearance under subsection A to the borrower's servicer, affirming that the multifamily borrower is experiencing a financial hardship during the COVID emergency. What that means is that if you are suffering lost income as a result of your residents not paying you because of the COVID emergency, then you are allowed, as the owner, the multifamily borrower, if you have a federally backed multifamily mortgage loan, that is, you're allowed to make a phone call to your servicer and say, hey, we need some forbearance on our mortgage payment to you this month because we are suffering financial hardship. Our residents aren't paying us. That's it. The government then said that the forbearance period that you're entitled to ask for is 30 days. The servicer is required, after they get your phone call, they're required to document your financial hardship request, provide the forbearance for up to 30 days, and they're also required to allow you to extend that forbearance for up to 2 more months, so a total of 90 days upon your request, as long as you make that request for an extension during the covered period and at least 15 days before the end of the 30-day forbearance. Fine. If you do that, so any multifamily borrower is allowed to ask for up to days of forbearance. Whether that means, it doesn't mean forgiveness, I think is the way to say it. Note that they use forbearance, not forgiveness. That does not mean that you don't have to make your mortgage payments. It means that you don't have to make them these 3 months. Now, what we don't have is any guidance from the feds yet about how is that going to be practically implemented. When a servicer gets that request, what is the servicer supposed to do? Are they supposed to simply just tack on 3 months to the end of your loan term, basically moving everything back 3 months? Are they tacking it on and making you repay those amounts as part of your mortgage payments over the next 12 months? What are they going to do? And the answer is nobody knows. And so I don't have any answers for you yet today because the government hasn't issued any guidance on how they want the servicers to handle those requests. What specific guidelines the servicers are going to be required to follow. I'm sure we will hear more soon, and we will update you accordingly. You are not required to take the full 90 days if you don't want to. Paragraph 2 of item C, forbearance period, says that you have the right to discontinue your forbearance at any time. So if you realize that you don't want to have all 90 days stacked up at the end, you can choose not to. If you do, then item D here is renter protections during forbearance period. So if you elect to have forbearance, then this statute obligates you to provide protections to your tenants as a quid pro quo item in exchange for the government giving you forbearance on your mortgage loan. During the period of your forbearance, during those 90 days, you are prohibited from evicting or initiating the eviction of a tenant from a dwelling unit located in or on the applicable property solely for non-payment of rent or other fees. So again, that immediately excludes reasons not non-payment of rent. You're not allowed to charge any late fee, penalty, or other charge to a tenant described in paragraph 1 for the late payment of rent. So if you seek forbearance, you're not allowed to charge late fees. The notice section is item E. A multifamily borrower, i.e. our clients, that receives a forbearance under the section may not require a tenant to vacate a dwelling, move out of their apartment, before the date that's 30 days after the date on which the borrower provides the tenant with a notice to vacate, and they may not issue that notice to vacate on paragraph 1 until after the expiration of the forbearance. So this is all to say that if you seek forbearance, then you have to provide protections to your tenants. Now, what's really interesting about this is that the very next section, 4024, which we're going to get to, says exactly the same thing over again, applies to exactly the same people, but creates an even longer window of time for all of these same forbearances and renter protections to exist. And so a lot of my clients have already come to me and say, I thought that we only had to give forbearance and stop late fees if we sought forbearance under that section of the statute. And if we didn't have to do that, which is true. If 4023 that we just went through was the only part of the law, then that would be 100% right. If you sought forbearance on your mortgage payment from your federal servicer, then you have to agree to provide these renter protections, waive late fees, not institute new eviction proceedings while you're under forbearance. That could be 30 days, that could be 60 days, that could be 90 days. But the government goes on to have the very next section make all of that seemingly meaningless. Because if we go to 4024, which is next, almost, closer. Scroll up just a little bit more.
It's in the, is it not showing in the center of the page for you? 4024 temporary.
Oh, there it is. My fault. Yep. Okay. So 4024, temporary moratorium on eviction filings. This section is the one that actually matters, because regardless of forbearance above, this section says that if you are a covered property, which is defined in number 2 below, a covered property is any property that participates in a covered housing program or the rural housing voucher program, or B, has a federally backed mortgage loan or a federally backed multifamily mortgage loan, which is exactly the kind of loan we just covered in 4023. If you have a federally backed multifamily mortgage loan and you ask for forbearance, you have to give the resident protections. Well, this section says if you have a federally backed multifamily mortgage loan, you have to give them the protections anyway. So if you scroll down, so now that you know, so the question then is, the big question, the homework that I was referencing is right what we just talked about. Item 2 is, what is a covered property? And the question is, does your property have a multifamily, does your property have a federally backed multifamily mortgage loan? Finding out the answer to that question is going to be complicated. And we are in the process of telling all of our clients that this is what you have to do before you know whether you're even allowed to charge a late fee next week. This is literally homework you have to do immediately. To know if you do, you have to go to this section right here on your screen, section 4, federally backed mortgage loan. This is the definition. So does your property have one of these loans? A loan that is A, secured by a first or second lien on residential real property, designed principally for the occupancy of from 1 to 4 families. Oh, sorry, that's the mortgage loan. So that's if you're a single family operator, this section applies. But if you go down to number 5, federally backed multifamily mortgage loan, that's the one that most everybody on this call wants to know about. So the term federally backed multifamily mortgage loan, the answer to the question of does my property have one of these is found here. A, it's secured by a first or second lien on a residential multifamily real property designed principally for the occupancy of 5 or more people. Obviously, if you have a multifamily community, it does. It meets that criteria. And B, it's a loan that is made in whole or in part, a loan that is insured by, a loan that is guaranteed by, a loan that is supplemented by, or a loan that is assisted in any way by any officer or agency of the federal government, like Fannie Mae, Freddie Mac, HUD, or other governmental agency in connection with a housing or urban development program administered by the Secretary of Housing and Urban Development, or a housing or related program administered by any other officer of agency, or is purchased or securitized by the Federal Home Loan Mortgage Corporation or the Federal National Mortgage Association. That is a very dense definition. Loans on multifamily properties have a million different shades of gray in what they are, how they're dealt with, and whether or not they meet that definition is virtually impossible to discern without being the actual lender themselves. So you're going to have to very quickly get confirmation from your lender about whether your property does have a loan that is made in whole or in part, or is insured by, guaranteed by, supplemented by, or assisted by in any way some agency of the federal government. So when you hear that that's what everyone is doing, this is why you have to do it. Because if you have a federally backed multifamily mortgage loan, regardless of whether you sought forbearance under the previous section we just talked about, then B, the moratorium kicks in. During the 120-day period beginning on the date of enactment of this act, which was Friday, March 27th, the lessor of a covered dwelling, again, a covered dwelling is one that has a federal multifamily mortgage loan on it. The lessor may not do any of the following things for 120 days. That is through the end of July.
So that is calendar days?
120 days, calendar days. So it should be something on or about July 25th. You may not make or cause to be made any filing with the court of jurisdiction to initiate a legal action. So you may not send any cases to the courthouse. We, as a firm that represents lots of you, if you are covered, if you have a covered property, we will not send any cases to the courthouse for you during the moratorium period. Now, it only says you may not make the filing with the court, which is great news because it allows us to get cases ready for you during the moratorium period, even if you are covered. But you may not file cases with the court of jurisdiction to initiate a legal action to recover possession of the covered dwelling for non-payment of rent or other fees or charges. So you'll note there that there is a clear carve out for eviction types that aren't non-payment of rent. Those types of evictions are not barred by the moratorium officially. 2, during the 120-day period beginning on March 27th, you may not charge fees, penalties, or other charges to the tenant related to the non-payment of rent. So earlier someone asked about NSF fees. I cannot tell you other than this is the definition you have. Your question depends on whether you consider the NSF fee to be one that is a fee, penalty, or other charge related to the non-payment of rent. If the payment that they bounced was for rent, then I think you cannot charge them an NSF fee. If the payment that they bounced was for a security deposit, you probably can. But the definition is here. And what it says is, it says plainly, you cannot charge fees during the 120-day period for any action by the resident relating to the non-payment of rent. So that's for sure late fees. And it's for sure NSF fees on a payment of rent. And penalties, of course, you're not allowed to charge penalties in North Carolina anyway. But even if you had that provision in your state law, you would be prohibited during the moratorium period from doing that. So now you see why the homework is so time critical. You cannot charge late fees on April the 6th unless you know for sure that you are not prevented under the moratorium from doing so. And to know that, you have to know whether your property is a covered property. And to know that, you have to know whether you have a federally backed multifamily mortgage loan or not.
Chris,
So,
2 questions that tie into what you're saying right now, just for clarification.
Yep.
What if they
Yep.
don't take any loan forbearance? They don't take any government help? Does that still apply?
Yes, that's exactly right. The difference between section 4023 and 4024 is that if you took forbearance under 4023, you're obligated to give the tenants a break during the period of your forbearance. But under 4024, it doesn't actually matter whether you get forbearance or not. If you are defined as a covered property, then you are required automatically to follow the 120-day moratorium.
And if they don't have a loan or a lien, they own the property outright?
If you own your property outright, then you are not covered under Section 5. You do not have a federally backed multifamily mortgage loan because you own it free and clear. And so then you are not, and you are eligible to conduct business as usual, including late fees, including eviction filings. You know, and again, you can file eviction cases in accordance with the procedures of the state you're in. So in North Carolina, if you own your property free and clear, you can file evictions for anybody that doesn't work with you to come up with a payment plan that is satisfactory. And we will schedule them in accordance with the court's procedures right now.
And you touched on this just a little bit, but if they use our service, They're not breaking
Yep.
the rules by giving the case to us because we're not going
Right.
to actually send it to the court without making sure they meet all the criteria, right?
Correct. One of the things that is very clear from this is that the moratorium applies to the initiating of a legal action in court, and that is a very specific item. It's very easy to differentiate that from our work in processing the case and getting it ready, because what you know is that at the end of the moratorium, there is going to be a floodgates opening phenomenon that occurs. And so from our perspective, it will be much more efficient for all of those cases to come to us in the ordinary course of business. We will continue conducting our business as usual, processing all the cases and making them ready, so that when the moratorium period ends, they will already be prepared and able to be submitted to the court without further delay. So our advice to our clients is going to be, it is in your best interest to keep sending us all of the cases as they come due, even if you are subject to the moratorium, so that the case can't be filed or initiated at the courthouse. We will keep track of that for you, and we will simply have the case ready, and we will move it forward as best we need to when the time is right. Now, the last thing I want to talk about quickly, there is also a notice provision in paragraph 3 right below that. The moratorium says you can't cause evictions to be made, you can't charge fees, and then the last item, C, is notice. So when the moratorium runs out, if you were a covered property, you are not allowed to require a tenant to vacate the covered dwelling before the date that is 30 days after the date when you provide the tenant with a notice to vacate. And 2, you may not issue a notice to vacate under paragraph 1 until after the expiration of the moratorium period. So this is a really substantive problem. When I mentioned earlier, there's a lot of issues that remain to be addressed. This is probably at the top of my list. This says that if you are subject to the moratorium, you can't initiate a lawsuit at the courthouse until after 120 days have passed. Except this section says you can't actually demand someone vacate the premises, which is a required step in North Carolina's eviction process. You must demand possession before you can file the case. This says that you can't demand possession with anything less than 30 days notice, meaning you can't initiate your lawsuit until 151 days after March 27th, which is August 25th. So these cases, if this isn't clarified, will be in the queue for maybe as many as 5 months before they can go to a courthouse. And that is something that NAA is already aware of and is already going to work with the federal government to try and make this work differently or better in its final version between now and 120 days from now. We hope that there will be additional stimulus packages to which additional language can be inserted, clarifying and fixing this very big issue. Because even under 4023, the forbearance that you have available is only 90 days max. But if your residents can't be evicted for 150 in practical reality, that makes no sense. It's a complete imbalance, but that's what the law says today. And so that's why there's a lot of this stuff that is going to change drastically. There's going to be a lot of additional communication about it. The federal government is going to be involved almost certainly, and we will have updates as we proceed forward from here. But for the time being, if you have a multifamily property that has a covered loan, then you need to be aware that you are basically going to have no choices other than to try and work with your residents and have your law firms try and help you spur your residents into reaching agreements with you. When you send cases to us, we're going to be actively participating with encouraging the residents to do what the governor of North Carolina encouraged, which is entering into payment agreements so that legal action isn't necessary. Even if we can't file now, having the case in our hands or your other attorney's hands, and it will allow them to get the case ready. It will allow them to then notify the tenant that you have gotten the case ready and that they are going to be subject to an eviction action if they don't do what Governor Cooper suggested, which is work cooperatively to come into a payment plan arrangement that's agreeable to both parties. The resident needs to know that you aren't just sitting by doing nothing, because the federal government has made it impossible for you to charge them or penalize them or otherwise economically incentivize them into compliance. So your only remedies really are going to be limited to what can your attorneys help you do. You can send letters that just beg and plead and ask them, But if they've started ignoring your letters, then there's only one other choice, and that's call your lawyer and see if your lawyer can put something on letterhead for you that might help. But this is what your new reality looks like for the next 120 days. If the government does nothing else and they don't change this law, there's going to be a whole lot of limitations on your options if you are a property that has a federally backed multifamily mortgage loan.
Chris,
So again,
we've got a few questions. Two or three of them are related to timing, as in if they had something that had already been filed before March 25th, 27th, fees that had accrued before the passage of the act. You want to address those?
Yeah, so it's really clear. It's easy. The answer is you do not, the moratorium does not apply to cases that are already filed. During the 120-day period, you may not make or cause to be made any filing to initiate a legal action. If on March the 25th, well, in our case, if on any date, March the 25th, you had filed in Mecklenburg County an eviction action, then that action is not within the 120-day moratorium, and so it is not prohibited. Those cases should be preserved and acted on because they will be some of the few that you have permission to do without question.
Okay, and if it hasn't been filed, but say they have a late fee based on a rent balance that was accrued before the 27th, can they still file that fee or
so again,
charge that fee?
The ability to charge a late fee is 100% dependent on whether you are a multifamily, federally backed multifamily mortgage loan holding property. And if you are, then you may not charge a late fee at all. If you are not a covered property, then you can do exactly what you always would have done before and charge whatever fees you were allowed to charge by law under North Carolina's late fee statute.
Okay.
But you have to know the answer to, are we a covered property or are we not?
Okay. Here's a fairly deep constitutional question for you. Is 4024 a violation of the Fifth Amendment? Protection of rights to property.
It's a violation of your rights to redress, too. It's almost certainly unconstitutional, except for the fact that this is a national state of emergency, and it's been declared as such for quite a while now. And I think under the Emergency Powers Act, the government is going to take the position that they have the right to temporarily limit your access. They are not depriving you, they are postponing. And I think that's the way they're going to take this. North Carolina is doing the same thing. When you're not depriving people of rights, but you're postponing their ability, then it's a much different analysis from a constitutional perspective. That's why the government feels like it's okay to do this, because it's a time-limited event that is, under basically all analysis, a reasonable period of time under the circumstances. Okay. And I think the government is going to defend itself constitutionally on the basis of we are postponing, not depriving.
Okay. Does this prevent them from reporting to collections or credit the debt that they are accumulating, that residents are accumulating?
There's nothing in this section that relates to that. It only prohibits you from charging late fees or penalties or other charges. And so as long as you're not adding fees relating to the late payment of rent, then if you have a protocol where you are reporting people to collections as part of your standard operating procedure, then there's no reason why you have to suspend that pursuant to this moratorium. Okay.
Clarification here, this applies to all residents, no matter if they are virus related or not. And I believe that is something that that's an NAA ask, is they are going to go back and see if it can get further defined.
Limitation. That's right. Yes. As of right now, the moratorium applies to your whole property. Every person on it, even those of us who rent a property like me, who has a lease that I pay rent for every month and have no loss of income and have no practical impact from the virus other than having my days turned upside down. There's no reason why I should not be subject to being the defendant in an eviction action if I chose to just not pay my rent.
Okay.
I have no practical impact, but the statute doesn't care. My property almost certainly is a multifamily, federally backed multifamily mortgage loan holder property, and so they would be prohibited from even trying to evict me if I didn't pay. And that's a big problem.
All right. Yeah, and I will say that I was on a call on Friday. I have subsequently followed up with NAA, and they are definitely going back to ask for that for that clarification, for it to be
Oh, yeah.
better defined.
Yep.
Another question, would Wake County Shelter Plus program that supplements payments be included in government assistance?
I don't think I understand how the question applies.
I'm thinking, I was hoping you would. I think maybe in the sense that if it's a federally backed program, maybe would it apply?
Gotcha. Oh, the answer is I don't know. Everything about who's covered and who meets the definition of multifamily mortgage loan, I am specifically not well versed in anything having to do with Fannie Mae and Freddie Mac mortgage programs, and so I've told everybody, all my clients said, listen, there isn't any way I believe that you know the answer to this question without asking your actual servicer. The use of the phrase "or otherwise assisted in" the issuance of the loan is so broad that I don't think anybody can do it without enlisting, unless you're the actual CFO of the company and know the mortgage documents yourself. I think everybody needs to get their lender to confirm for them in writing, do we or do we not meet this definition?
I'll ask my own question here because this came up on a call I was on this morning.
Yeah.
Would a letter from for your purposes, in terms of deciding to file or not, would a letter from a CFO suffice, or do you need documentation from a mortgage company?
At the end of the day, when you file a case, you're going to have to provide an affidavit to the court attesting to your eligibility to do so. So the answer is going to be, I don't really care what you use. You're going to be the one that puts your name on the affidavit saying that you know this to be true, and you're going to swear it under penalty of perjury. So I'm going to usually tell my clients, I'm going to twist that right back around and say, well, it depends on what you're comfortable putting your name on, because you're the one signing the affidavit, not me. So
Okay.
If you're comfortable with your CFO doing it, then fine. If you're not, then I suggest you get your lender to do it.
Okay.
But it won't matter to me. At the end of the day, for the time being, it's fine. But when it comes time to file the lawsuits, the actual clients that we work with, regional managers and vice presidents and whatnot, they're going to be the ones signing the affidavits to the court saying we have investigated and these are the facts. That's not something that our attorneys would have knowledge of, and so we wouldn't be allowed to attest to them in an affidavit form. So the question really is, what are you comfortable with?
Gotcha. Okay. A little more clarification is being asked for, and something you answered before, and I'll read it so that I get it right. Sorry, I think I need clarification. Assuming the landlord is a covered property, can a late fee be charged on pre-March 27th debt? Certainly none for April forward.
Not if it's already been charged. Whatever's on the ledger as of March 27th can stay there. You cannot put new fees on the ledger after March 27th if you are a covered property.
Okay. Portfolio with a combination of owned assets and federally backed assets, may we establish eligibility requirements that are property specific based on lending? For example, may
Yes.
we file on residence and charge late fees at an owned asset and not file on residence at a property that has federal backing?
That is exactly the project we are undertaking as we speak. The partners of my firm are doing that exact project right now while I'm giving this lecture. Property by property, we're checking off our property list. Each property has its own answer. And so, yes, you not only can, you should, you must.
Okay. All of our renewals start, I'm going in order here. They see it on the screen, so hopefully we get to everything. All of our renewals start August 1st, 2020. If a resident who has a renewal falls behind now, may we require them to participate in a payment plan or cancel the renewal? Does that make sense? Is it really illegal?
Say it one more time.
Okay. All of the renewals start on August 1st, 2020. If a resident who has a renewal falls behind now, may we require them to participate in a payment plan, or do we cancel the renewal? Does that make sense? Is it really?
I think that one is so fact specific that you would really need to do that one offline with a lawyer as an actual legal question that you ask about your specific program. It's not easy. It doesn't easily fit into the definitions of this statute as to how it would apply. So I think that's one you would have to get offline from an actual, reach out to your attorney and ask them that actual question with the documents so they can review them and figure it out.
Okay. We have 4 more questions queued up. I know we're running long, so kind of grind through these really quickly. We did a non-renewal because someone never paid a water bill, and we can't evict for not paying water. Is that also not a non-renewal?
Well, that's a very specific legal question that for sure is beyond the scope of this. I can't give legal advice about specific fact circumstances, but yeah, regardless of the reason for the non-renewal, if you're a multifamily mortgage property that's covered under the CARES Act, you're not going to be able to file it anyway, because the notice period means you can't send them a notice to vacate until 30 days after the 120 days moratorium runs out. Even if it's a holdover case that you non-renewed, the law still says that you have to give them a 30-day notice, and you can't issue that 30-day notice until after the 120 days run out. Another problem that needs to be fixed. But yeah, whether you're even allowed to file it or not under North Carolina law, you'd want an attorney to review that question. Our law about sub-meter bills and what you can do and can't do is pretty specific, so you'd want that one to be analyzed by a North Carolina attorney. But in terms of whether you could even file an eviction if it is proper, that's also a CARES Act issue you'd have to analyze after the fact. Okay.
Is the NAA buyout agreement supposed to be signed at time of the lease signing or at the actual lease break?
Very short answer to that question is that most people have an early termination agreement signed at the time the lease is signed, but that doesn't make it valid as of 7 months later. That makes it a notice to the resident of what the terms they can expect to receive are. If you want to actually hold people to an early termination agreement, you have to get them to sign it at the time they want to terminate. Basically, my advice always is in my seminars is that all you have to do is take the same form and have them re-sign it and redate it, saying that they want to accept those terms now, that it's 7 months later and they need to leave to go take a job transfer. But if you're trying to rely on a document that was signed 7 months ago at the same time they signed a lease, you can't have 2 contracts in place at the same time. And so the answer is you have to get them to sign it in real time at the time they want to terminate if you want to rely on it.
Okay. And my apologies, these might be repetitive. I'm brain dead, but let's see what we got. What are we legally allowed to charge for true skip in regards to fees and rent?
Oh, well, that's a situation you should definitely reach out to your counsel about that. That's outside the scope of today. But what I said earlier is the same. They have a contract with you. You're allowed to charge them rent on the 1st of the month and a late fee on the 6th of the month, except under the CARES Act. You may not be allowed to charge a late fee. And so if they skip out, they haven't changed their contract. Their contract still says what it says. You're allowed to charge what your contract says, rent, on the 1st of the month until the lease runs out or until somebody else moves in. That's.
Oh, you muted again. There you go. Last one, I think you just answered, I think, maybe not quite specifically. It has to do with a lease termination fee. If they terminate before 7/25, can you charge a termination fee?
Yeah, same answer. But yeah, charging a termination fee is a matter of agreement between you and the tenant. There's no such thing as an automatic termination fee that you can just assess to people. There never has been. Under our law, that's not permitted in North Carolina. If the resident hasn't agreed to do it, if they sign an early termination agreement saying, I agree to pay 2 months rent, then you can. If they don't sign an agreement and they just move out on July 25th, then they haven't agreed to pay an early termination fee, so you can't charge them.
All right. Well, Chris, you did it all. You got all the questions answered. All right.
Well, it took 90 minutes this time, but thanks to everyone. It was a little complicated. Thanks for everyone for bearing with us, and for everyone who's watching that had to jump off. Sorry that we ran longer than we thought. Probably should have known this one would take a little longer than an hour. But hope everyone gets what they need, and I'm sure we will have another one soon.
Great. Well, thanks again, Chris, for doing it. Meg and Triangle Apartment Association, thanks for hosting, as always. Thanks to all of the affiliates who promoted this around the state, and most of all, thank you for everybody who participated and asked some great questions. Hopefully, we're able to answer many of them. A reminder that this has been recorded. We will post it. You'll be able to share that with your colleagues who weren't able to make the call. And I believe it takes a while for the video to get processed, so we'll get it out to the registrants as soon as we can.
Sure will. Thank you so much, John, for moderating today. We really appreciate your help. Thank you, Chris, for taking time out of your day to speak to all of the attendees and everybody who watches the recording afterward.
Thank you, Meg. Thanks for the help.